Good morning, good afternoon. Thank you very much for joining our meeting today. This Oxford's webinar series addresses issues around economic aspects of intellectual property law. Today we will be speaking about damage calculations for non-economic harm in intellectual property rights. Our guest speaker is Professor Tom Cotter, who has recently published on this topic. The paper will be shared with everybody. And I would like to say, for those who don't know Oxford is a spin-out from the University of Oxford. It's been up now for nearly 10 years, and it's a law and economics consultancy that is passionate about the valuation of intellectual property, economic effects of public policy formulation in IP, and coming better to grips with managerial aspects of intellectual property law. With that very brief introduction, I now pass on the floor to Professor Cotter. God willing, I'll have an idea how to do this. This software is very new to me too. Yeah, 1 second. Tom, you already have the floor while I'm trying to make you.
Yes, so as Roy said, I have a paper coming out in the Hastings Law Journal soon. It is already available online on the SSRN website, and it is titled Damages for Non-Economic Harm in Intellectual Property Law. And so to put this topic in some context, U.S. law, in particular, sometimes distinguishes between so-called economic or pecuniary harms or losses or damages on the one hand, and non-economic or non-pecuniary harms, losses, injuries on the other. And there is no hard and fast distinction between economic and non-economic harm. The definition of what falls into one category as opposed to the other sometimes can vary from one body of law to another. But a sort of a rough and ready distinction is that economic harm includes such things as lost profits, lost wages, expenses reasonably incurred to mitigate the consequences of the defendant's unlawful conduct.
And you have been made the host.
All right, let's see. Yes, let me make sure I can get if I can advance my slides, that will help. There we go. Whoops, wait a minute. There we go. All right, so that's the paper. And anyway, the introduction, as I was just saying, there is this distinction between economic harm and non-economic harm in US law, and I believe the laws of other common law countries as well tend to use this terminology. Non-economic harm, in contrast to economic harm, tends to include such things as pain and suffering and personal injury cases, emotional harm, mental anguish, feelings of humiliation, that sort of thing. And also loss of reputation is usually, though not invariably, classified as a species of non-economic harm. So again, no hard and fast distinction between these two things. Different people might include different things within one category or the other, but one sort of rough and ready distinction is that the types of harms that we are likely to classify as economic harms tend to be more susceptible to quantification, measurement, than non-economic harms. Now, again, sometimes that's a rather blurry distinction in intellectual property law, in particular, when courts award reasonable royalties and they employ something called the hypothetical bargaining framework. That is really an imaginary negotiation. It is not a real royalty. So again, the distinctions are not always hard and fast, but roughly speaking, economic harms, things like lost profits, are more susceptible of a precise quantification than non-economic harms are. And the concept of non-economic harm is often referred to in the European legislation and case law as moral prejudice, very literal translation of the French préjudice moral. There are some commentators who will argue that, technically speaking, moral prejudice in the civil law countries refers more exclusively to mental distress, and that other types of non-economic harms, such as loss of reputation, should have a different term. But I'm going to use the term moral prejudice as being synonymous with non-economic harm for our purposes today. So the paper that I've written explores the extent to which intellectual property law, and primarily in the United States, but not exclusively. I do have a section of the paper that discusses law within the European Union as well, discusses the circumstances in which owners of intellectual property rights are allowed to recover damages for non-economic harm, and how those damages may be measured. And towards the end of the paper, then, I delineate various principles for determining, first of all, whether courts should award damages for non-economic harm in intellectual property cases, and if so, how they should quantify that harm. These two inquiries are, of course, related, because the more difficult it would be to quantify non-economic harm in some sort of reasonably objective, non-arbitrary way, the more difficult that is, the weaker the case might seem for even attempting to award damages for this sort of harm. So they are related inquiries, but I will try as much as possible to keep them separate. And this project, just to explain why I got interested in this, I've been writing about damages in IP cases for quite a long time now, over 20 years. But it only really came to my attention maybe 5-6 years ago that courts in the European Union and courts in the United States often had very different ideas about whether these types of harms should be compensable at all, and if so, how they should be measured. And I began to collect case law and commentary across the entire range of intellectual property rights. And I thought this would make for an interesting paper that, at least to my knowledge, no one had attempted to do in a comprehensive fashion previously. So some background considerations to have in mind as I go into this discussion of whether and how courts should award damages for non-economic harm in IP cases. One possible analogy that we might imagine could be useful is to look at how or whether courts award damages for non-economic harm in other types of property cases. So in cases involving torts against real property or personal property, do courts ever award damages for mental suffering or that sort of subjective harm? And the answer, at least in the US, and I believe this is at least roughly speaking true in other common law jurisdictions as well, is that the traditional rule was no, that courts usually would not award damages for non-economic harm in response to trespass or conversion of personal property, that sort of thing. Although, as I explore in the paper, the very outset of the paper, beginning at around page 10, there actually are a number of exceptions to this rule. Many courts in the US would say that if someone intentionally or willfully or maliciously interferes with another person's enjoyment of real property, that the defendant, the tortfeasor, actually may be liable for non-economic harm that results therefrom. And so we have seen some chipping away of this traditional rule in the United States, more so in some jurisdictions than in others. Another possible analogy might be to consider other bodies of law, non-IP law, that specifically deal with various types of non-economic harm, protecting it, measuring it, and how do they do that? What are some of the limitations? What are some of the challenges that we find in these other bodies of law? And so one very obvious example, if we are talking about reputational harm, would be to consider the law of defamation, libel, slander, injurious statements, false statements that might injure a person's reputation. So there's a portion of the paper beginning at page 11 where I talk about the common law of defamation. This is a body of law that in the United States evolved from English law, but has evolved in a quite distinct fashion from what is currently the law in England. It's a very complex body of law, and without going into all the details here, at least in the US, the courts in various jurisdictions made distinctions between written defamation, libel, and oral defamation, slander, different rules relating to these two things. In recent years, actually not all that recent anymore, beginning in 1964, the US Supreme Court began to apply First Amendment considerations to private defamation actions. The concern being that if it is too easy to bring a defamation suit, particularly against a public official or a public figure, that might have a chilling effect on freedom of speech. So it's a very complex body of law. Some of the complexity is really unnecessary, is more the result of historic accident. But for our purposes, one of the takeaways that might be relevant from this body of law is that in many, though not all, settings, courts will allow the trier of fact, which in the US will often be a jury, to award so-called presumed damages. That is to say, general damages that are not tethered to any demonstrable or quantifiable harm to reputation. In a sense, the jury can almost sort of pluck a number from the air and say, this is the amount of money that we think would be appropriate to compensate the defamation plaintiff for the harm that his or her reputation has suffered. Because of the countervailing free speech considerations, the ability to award presumed damages is limited in some circumstances at least, or additional conditions must be satisfied for that to be available. For other types of defamatory statements, slander, for example, at least certain types of slander, the court takes a more skeptical approach, the law takes a more skeptical approach, and will allow the trier of fact to award damages only for so-called special harms, or at least there has to be proof of special harm before the jury could award any further damages for general harm. So special harm would be some sort of economic injury, quantifiable injury that the plaintiff has suffered as a result of this untrue attack on his or her reputation. So again, the takeaway is that general damages to compensate for injury to reputation are at least sometimes available for defamation, but because of the various countervailing considerations relating to freedom of speech, among other things, there are limitations. The courts impose a number of additional conditions, particularly if the speaker, if the defendant is speaking about a public official, a public figure, or a matter of public concern. Another body of law that might have some relevance here, because courts will often award non-economic damages in this area as well, involves the right of privacy. So again, very complex body of law. In the US, we have the common law privacy torts, which began to develop in the 19th century and were more or less classified in the mid-20th century by William Prosser as falling into 4 different types of common law privacy torts. In the modern day, we also have various statutory causes of action that are designed to protect privacy. So without going into all the details here, but in public disclosure of private facts or the appropriation of a person's identity for commercial purpose. For those types of torts, at least historically, courts have awarded usually general damages to compensate for the mental anguish, the humiliation, that sort of harm that the plaintiff may suffer as a result of the revelation of this type of information. in the modern world, where we have various statutory causes of action as well that might address things like identity theft, courts even to this very day are struggling with the question of whether merely mental injuries should suffice as a cognizable harm for purposes of violations of various privacy claims. There are other bodies of law as well, again, some of them dating back centuries in the common law, but two other ones that might be relevant in the present context. There is a common law tort for infliction of emotional distress, both intentional infliction of emotional distress and negligent infliction of emotional distress. Again, since distress is just part of being alive, having to function in the real world, the courts have been somewhat skeptical about allowing people to recover damages for these types of harms too generously, and there are a number of conditions that must be in place before a person can adequately state a claim for either intentional or negligent infliction of emotional distress. But when those conditions are present, courts will allow the trier of fact to award general damages to compensate for that mental anguish. So in any event, one of the questions that the paper poses is whether these other bodies of law provide appropriate analogies, or at least do they give us some idea of the possible tools that may be at our disposal if we think it is a good idea to compensate intellectual property owners for these various types of non-economic harms. And maybe some of these non-economic harms are more relevant to certain bodies of IP law than to others. In the European Union, as I mentioned, there is the concept of moral prejudice, and there appears to be, at least as a matter of directive law, there appears to be more receptivity to allowing courts to award damages for non-economic harm, moral prejudice, throughout the entire range of intellectual property cases. I say that because we have Article 13 of the Intellectual Property Rights Enforcement Directive, which states that in setting damages for the infringement of intellectual property rights, the judicial authorities of the member states shall take into account all appropriate aspects, such as the negative economic consequences, including lost profits, which the injured party has suffered, any unfair profits made by the infringer, and in appropriate cases, elements other than economic factors, such as moral prejudice caused to the right holder. So at least on its face, it would appear that the directive requires the judicial authorities of the member states to take moral prejudice into account across the range of intellectual property claims. We also see a very similar provision in the recent Trade Secrets Directive. So even in that body of law, at least it seems to be within the contemplation of the European Parliament that there could be moral prejudice that would be compensable depending on the facts. And there has been some case law before the Court of Justice for the European Union, most notably the Liffers case from 2016. I'll talk a little bit more about that case in a few minutes. So moving along, the rest of the paper then is devoted to considering 5 specific areas of intellectual property law and the extent to which courts in the US primarily already do or perhaps should award damages for non-economic harm. So to begin, there's trademark law.
There's
Go
a
ahead.
question
There's a
actually.
question.
Yeah, from my young thing is the reason why the directive includes inappropriate cases and does not simply omit it. Is there a purposive construction to it? Does that question speak to you?
Well, I can't really speak to why they included that language. I can speculate that the idea might have been that it would be the unusual case, say in a patent dispute, where moral prejudice would be at issue. And so maybe that's a way of just trying to clarify that these damages would not necessarily be appropriate in every case. but in appropriate cases, they might be. But again, that's more speculation on my part. I cannot really speak authoritatively to why they use that particular language. Beginning with trademarks, this might seem to be the closest fit, or at least a very close fit, with reputational harm, because a trademark is often viewed as protecting, indeed embodying, a company's goodwill. And reputation and goodwill, sometimes those terms are actually used synonymously. It is probably more accurate to say that reputation is one constituent element of goodwill. Goodwill being the ability of a company, of a firm, of a brand to attract repeat business. And that might be attributable to many factors, but certainly the firm's reputation would be, in most instances, a very important aspect, a very important constituent element of its goodwill. So if a trademark is intended to protect a company's goodwill, then it would seem to be fairly straightforward that reputational harm to the company's goodwill, should be a cognizable harm for at least some types of trademark infringement. And I go through some examples in the paper. Not every instance in which someone infringes a trademark necessarily jeopardizes the trademark owner's goodwill, its reputation, but at least some of them do. And so when that is the case, it would seem natural to think that that sort of injury would be a cognizable harm. As for emotional harm, however, that seems to be a little bit less likely, at least in most trademark cases, in particular when trademarks are owned by non-human entities, which I think is probably empirically most of the time. Most trademarks probably owned by corporations or partnerships, not by individual humans. So at least in those cases, it would seem to be a little bit less likely that emotional harm would be on the table. But if the trademark is owned by a natural human, then there might be at least some question about maybe if that act of trademark infringement causes the trademark owner, the human owner, to suffer some sort of mental anguish. Maybe they could argue that they are entitled to some sort of compensation. I think that is precluded actually in the US as a result of a Supreme Court decision from a few years ago called Lexmark, in which Justice Scalia reviews a portion of the Lanham Act, the federal trademark statute in the US, and seems to say that at least in the false advertising context, only commercial harms are cognizable. I suppose that might leave open the possibility that if you were asserting a claim for more straightforward trademark infringement and you were a natural entity, maybe you could argue that emotional harm is cognizable. But I think it's a fairly difficult argument to make, at least in the US. But reputational harm, at the very least, would be cognizable. Now, the standard remedies for trademark infringement in the US would include injunctions and damages of various types, lost profits, the disgorgement of the defendant's profits in certain instances. Again, there's a recent Supreme Court case just from about 6 weeks ago on that topic, the Romag Fasteners case. But what about damages specifically intended to compensate for injury to goodwill or reputation? More of a sort of a general harm to a firm's goodwill or reputation that might not be captured by an award of lost profits. What about that? And the answer is that courts sometimes do award damages to compensate for this residual harm to a trademark owner's goodwill or reputation, or sometimes, somewhat relatedly, damages to fund a corrective advertising campaign to try to address the harm to reputation by taking out this campaign of corrective advertising. The question, though, in all of these cases is exactly how do you do this in some sort of consistent and non-arbitrary way. It can be very difficult to quantify harm to reputation or harm to goodwill, although maybe it's easier in this context than in other types of IP contexts. And so I can say that because since most trademark owners are corporate entities, we could at the very least try to figure out what was the value of the firm's goodwill prior to the infringement, and what is the value of its goodwill now. There are ways to do that, accounting methods, particularly if the firm is publicly traded, but even if it is not. So at least that would give us some idea of what the maximum amount of the harm could possibly be. It would be a way of at least capping the damages and saying it couldn't have been harmed beyond this amount. Another possibility might be to award the defendant's profits resulting from the infringement, although there may not be any necessary connection between the amount of the defendant's profits and the harm to the plaintiff's goodwill. And so there is at least some risk of arbitrariness. We saw this actually, I would say, when 20, 30 years ago, when courts for a period of time were awarding corrective advertising damages that consisted of 25% of the defendant's advertising expenditure, which would not necessarily be tied in any rational way to the actual harm to the plaintiff's goodwill. There is another type of trademark tort recognized in the US, and to my knowledge, most other countries as well. At least arguably it is required by the TRIPS agreement for members of the WTO, and that is that owners of so-called famous marks have a right to prevent dilution, meaning in the US, the unauthorized, non-confusing or not necessarily confusing use of a mark that reduces its selling power. We certainly see this concept in the EU as well. In Canada, they simply call this goodwill depreciation, which seems to be perhaps the most straightforward way of thinking about dilution. It is actually a way of harming a firm's goodwill by making its trademark appear to be less valuable or less attractive, to have less of a sort of a cachet among the audience. Anyway, so in the US, however, there is a hitch. If you're trying to recover monetary compensation for trademark dilution, the statute explicitly says that monetary awards are available for willful dilution only. And as a matter of fact, damages are extremely rare in this particular context. I think in the paper we have only two relatively minor examples of courts in the US awarding damages for dilution. That raises the question, why the limitation? But I think there actually might be some good reasons for that. One is that, at least in my view, there's never been an absolutely compelling knockdown justification for having a dilution cause of action. There are various justifications that have been put forward for more than a century now, and eventually they have persuaded courts and legislatures throughout the world that there should be this cause of action, but none of them, at least individually, are extremely strong. So that might at least evince a certain amount of skepticism about whether we should be overly generous in awarding damages for this somewhat theoretically shaky cause of action. Also, it can just be very difficult to quantify the extent to which a diluting use of someone's trademark has caused harm to the trademark itself. So that's trademarks. I want to talk a little bit about another body of law that sometimes is classified as a type of intellectual property, sometimes not, but that is the right of publicity. So this is something that many courts in the United States have recognized over the years, many state legislatures. There is no federal right of publicity, so this is all state law, and there are some states that have adopted a right of publicity that may differ from what I have on the screen, or that have not adopted it at all. There are counterparts to the right of publicity in many other countries' laws, but at least to my knowledge, nothing exactly the same as the right of publicity in England or France or Germany. There are image rights, sometimes passing off law in the UK covers much of the same territory. Anyway, but it's not something that is the subject of any international treaty. It is not something that is discussed in any of the EU's intellectual property rights directives either. Anyway, the right of publicity in the United States actually has two sources in the common law. The first source is the right of privacy. So the common law right of privacy, one aspect of the common law right of privacy, according to many courts, many commentators, is that someone who appropriates for his own use or benefit the name or likeness of another individual is subject to liability for that invasion of privacy. So taking a private individual and thrusting him or her into the public sphere against their will can be viewed as an aspect of the right of privacy, a violation of the right of privacy. More recently, many courts, many state legislatures, the American Law Institute, which promulgates these restatements of the law back in the 1990s as well, have viewed individuals as also having a property interest in their name or their image or their likeness. And so the restatement of unfair competition, which the ALI published in 1995, recommends that states adopt the following rule: one who appropriates the commercial value of a person's identity by using without consent the person's name, likeness, or other indicia of identity for purposes of trade is subject to liability. So the first restatement looks at this through a privacy lens, the second restatement through a property lens. So anyway, again, many states have adopted the right of publicity either at common law or by statute, though again, no federal right of publicity. There is variation among the states. Some of them recognize or emphasize the privacy aspect, others the property aspect, others emphasize both aspects. Anyway, invasions of privacy, as I mentioned earlier in the hour, can cause emotional or even reputational harm, and there is a long history of compensating individuals for these sorts of affronts to their privacy. And of course, unauthorized uses of property, as we've seen, can cause harm as well. So to what extent are these types of harm cognizable for violations of the right of publicity? And the answer is, generally speaking, courts have been receptive to awarding damages for these types of non-economic harms for violations of the right of publicity. And one of the cases I talk about in the paper, one of the more famous cases in this particular area is Waits versus Frito-Lay from 1992. So some of you may be familiar with Tom Waits. He's an American singer, performer. He has a very distinctive sort of gravelly voice. And he has long been on record as saying he will never do commercial advertisements. He doesn't believe that that is what artists should engage in. He won't do it. Anyway, about 30 years ago, the people at Frito-Lay thought it would be a good idea to use a Tom Waits song in one of their TV commercials for Doritos, tortilla chips. And they couldn't get Tom Waits to agree to this. So they got a singer who could imitate Tom Waits's voice. And so they had the singer perform a song that Tom Waits was known for performing. I guess they got permission from the copyright owner in the song. And the singer sounded like Tom Waits, but it wasn't really Tom Waits. So anyway, Tom Waits filed suit against Frito-Lay for, among other things, violation of his right of publicity under California law. And the court in this case was willing to affirm a jury verdict in favor of Tom Waits. The damages were fairly substantial. The court awarded $100,000 for the fair market value of Waits's services, if he ever wanted to be an endorser. I guess that would be more in the nature of an economic harm, but then also $200,000 for injury to his peace, happiness, and feelings. So that's the emotional harm. And then a separate $75,000 award for injury to his goodwill, noting that his artistic reputation itself may have suffered as a result of what people would perceive incorrectly as him selling out. So at least in this case, the court was willing to award fairly substantial non-economic damages, both for emotional injuries and for reputational injuries stemming from the defendant's infringement of Waits's right of publicity. Moving on, there is copyright law. And so here's where I will talk a little bit about the Court of Justice decision in Liffers, as well as corresponding cases in the United States. So really the leading case from the Court of Justice for the European Union on non-economic damages in intellectual property cases is this decision, Christian Liffers versus Producciones Mandarina, case that came up from Spain in 2016. And it involved a motion picture work, this documentary that Liffers directed, titled Dos Patrias, Cuba y la Noche, about gay and transsexual people in Cuba. And so the defendant in the case took portions of this motion picture work and used them in a documentary on the topic of child prostitution in Cuba. And so Liffers took offense at what he viewed as the misuse of his work, the unauthorized use of his work. So he filed suit in Spain, both for copyright infringement, but also for violation of his moral rights. So really two causes of action. Anyway, the Court of Justice for the European Union was tasked with the question of whether or not, just on the copyright side, it would be appropriate to award economic damages, a reasonable royalty for the unauthorized use of the work, as well as damages for moral prejudice. And the court said, yes, under that Article 13 of the directive that I had on the screen earlier in the hour, both types of harms are available, again, as appropriate when proven in a given case. You can recover damages for both types of harm. And so that's at least one decision in Europe that, at least on my view, seems to stand for the proposition that courts will interpret the directive to mean what it says, that damages for moral prejudice are available across the range of intellectual property cases as appropriate. Now, in the United States, there are some cases in which courts have awarded I have a question here about moral rights in Europe, and I'm going to come up to that in a few minutes. So let me just hold off on answering that one just for a couple more minutes. I'm going to focus more specifically on the moral rights aspect of copyright shortly. For the present time, just focusing more on the economic rights of copyright owners. In the US, there are some cases standing for the proposition that a court may award damages to compensate a copyright owner for injuries to his or her reputation when such injury is alleged and proven. The leading case here is in some ways kind of a strange case, Harold Stores versus Dillard Department Stores, which I discussed at page 34 of the paper. This was a case involving copyright in fabric design, so patterns that might appear on a dress or a blouse, jacket, not the cut of the jacket, because that is not a copyrightable work as such in the US, but the pictorial design that might appear on a garment. Anyway, the defendant, Dillard, was found to have infringed Harold's copyright in these fabric designs, and among the headings of damages in this case was reputational harm. So at least this case appears to stand for the proposition that reputational harm is a cognizable injury in a copyright case, although it's at least somewhat dubious in my view whether the plaintiff really proved the amount of the damages suffered. The court awarded $262,000 for injuries to Harold's goodwill based on testimony, first of all, from Harold's CEO, that was the amount of their goodwill, but also expert testimony based on a survey of female college students, women who saw the infringing skirts at the defendant's store, said they were somewhat less likely to purchase clothes at Harold's within the next year because they would think it was overpriced. It seems a bit attenuated to me, but nevertheless, the court did award damages for reputational harm in that case. For the most part, however, courts in the US have resisted the urge to award damages for emotional harm in copyright cases, and I will come back to that in a few minutes. But the theory is that damages are available to compensate only for the market value of the work. in a copyright case in the US. But now I will talk about moral rights, because this is another aspect of copyright that most countries now recognize to varying extents, and you might think there would be more receptivity to awarding damages for non-economic harm in moral rights copyright cases. So for those of you who are not familiar with the concept, moral rights are viewed as, to some extent, validating the author's investment of his or her unique personality in a work of art, in a work of authorship. The concept was originally developed in the courts of France and Germany based on commentary that itself was sort of derivative of Kant and Hegel's musings about copyright in the late 18th and early 19th century. But anyway, moral rights are now codified in most countries' copyright laws and in the Berne Convention. And generally speaking, there are, among other things, but really two really important aspects of the moral right are the right of attribution and the right of integrity. The right of attribution meaning that the author of a work of authorship has an inalienable, non-assignable right to be properly attributed as the author of a work that he or she has created, and the right of integrity meaning that the author has some right to object to unauthorized modifications or distortions of the work, something that would compromise the author's artistic vision. Now, again, this could mean different things in different countries. Some countries, including France, take a more absolutist position that any change to a work that is an affront to the author's subjective sensibilities is a violation of moral rights. Most countries, and the Berne Convention as well, Article 6 bis, take what is viewed as a more objective position that the author has a right to object to any distortion, mutilation, or modification of the work which would be prejudicial to the author's honor or reputation. So you can see that there is this protection for the author's mental sensibilities, for the author's reputation. So you might think this would be one of the prime areas where courts would be receptive to awarding non-economic damages, and that is largely true, certainly in countries outside the US. Now in the US, moral rights were rather, were not favored for a long time. In fact, it was only in 1991 that the US Congress enacted the Visual Artists' Rights Act, which bestows moral rights upon authors, and even then only on certain types of authors of certain types of work. So it's a much more limited sort of protection than in many other countries. In the US, under this federal legislation, protection of moral rights is limited to qualifying works of visual art, so that includes paintings, sculptures, prints, and photographs produced for exhibition purposes only. It does not actually apply to motion pictures or music or literature or anything else. The rights are waivable in the United States, but they are not assignable, and they're not assignable anywhere because they are viewed as personal to the author. Anyway, we had a fairly recent decision in New York that involved graffiti art. So interesting case. Cohen versus G&M Realty was the name of the case before the district court. It was then affirmed on appeal earlier this year under the caption Castillo versus G&M Realty. Anyway, it involved 5 points. So the story is that there was a warehouse complex in Queens, part of New York City, one of the boroughs of New York City. And for many years, graffiti artists would tag the building with their art, and this was done with consent of the building owner. So there was authorization, there was consent on the part of the owner of the real property. But then at some point in time, the owner of the property decided that he wanted to develop the warehouses into condominiums, and so he was going to destroy the works of graffiti art. And so the artists filed suit under the Visual Artists' Rights Act, claiming that the destruction of these works of recognized stature would violate this federal statute. While the litigation was pending, the defendant actually had the buildings whitewashed, so the graffiti was destroyed even before they tore the buildings down. So anyway, the case then went to trial on whether or not the artists had a viable claim under the Visual Artists' Rights Act. And long story short, the court concluded that they did, that most of the specific works of graffiti art at issue qualified as works of recognized stature. This was high art. This was recognized by art critics, museum curators throughout the world. And the court awarded very substantial damages, $6.75 million. But it did so under the rubric of statutory damages. So this court, following other precedents in the United States, says that emotional harm, mental anguish, is not a cognizable harm in a copyright case, even a moral rights case. However, we do have this other option in the US in copyright cases of awarding so-called statutory damages, which are not necessarily tied to any amount of actual harm. Rather, the trier of fact can award damages ranging from $750 to $30,000 for each work that is infringed. And for willful infringement, the damages can be increased to $150,000 for each work infringed. And so that's what the court did here, largely for deterrence purposes. The court awarded the maximum statutory damages of $150,000 multiplied by the number of qualifying works to arrive at this figure just shy of $7 million. Finally, I'll say a little bit about patents, and then I will close with my proposed framework for addressing non-economic damages as a general matter. But even in patent law, there is at least some authority in the US standing for the proposition that an act of patent infringement that harms the patent owner's reputation for being innovative, for example, and there might be an unusual case where that comes up, but there are some examples, that is a cognizable harm under US law. It can be compensated with an award of general damages, as in a trademark case. I also noted, this is one of the articles that got me to thinking about this issue a few years ago. There's an article by Ronen Avraham, who's a very well-known law and economics scholar, and he published this article in the Texas IP Law Review a few years ago called "Should Courts Award Pain and Suffering Damages in Patent Infringement Cases?" And so he argues in this particular case that you can come up with examples of small inventors whose rights were ignored by large companies and who actually suffered, the small inventors suffered substantial mental and emotional harm, stress, just trying to vindicate their rights. And he argues that, as in other types of, say, personal injury cases, courts should be receptive to awarding non-economic damages to compensate for that emotional harm. As in the paper, I wind up disagreeing with him on that, but we'll get to that in a few minutes. But it's an argument. In the European Union, again, we do see some instances where courts have awarded non-economic damages, moral prejudice damages, even for the infringement of patent rights, although practice seems to vary considerably from one country to another. In this regard, I note, among other things, a very good article by Nicholas Fox and his colleagues in the European Intellectual Property Review from 2015, going through the different major patent jurisdictions within the European Union and the circumstances under which they award damages for moral prejudice in patent infringement disputes. There's quite a lot of variation. There's also this, I think, rather interesting case that Michel Montagnat brought to my attention a few years ago. He published a little blog post about this on, I think, the Kluwer IP blog. This was a case involving a European patent for the item depicted on the right, which was a beaded thong used for sexual stimulation. So someone actually got a European patent on this and successfully sued for patent infringement in Spain and requested damages for moral prejudice. The Court of Appeal of Madrid held that moral damages, daño moral, would include such things as psychological suffering or distress, etc., and that in theory that is compensable in a patent infringement action, although in this actual case the plaintiff had not proven mental distress resulting from the infringement. However, the plaintiff also was entitled to non-economic damages, moral prejudice damages for injury to reputation because the defendant marketed the infringing beaded thong in a plain cardboard box, which supposedly compromised the luxury image associated with the plaintiff's product. So at least within Spain, there was support for moral prejudice damages in the patent infringement context. So what should we do? What should the law be in this area? And that's what I devote the last part of the paper to discussing. There certainly are some reasonably strong arguments for awarding non-economic damages in IP cases, or at least some IP cases. And that probably the most compelling argument is that if we really take the full compensation principle seriously, then we should compensate these types of harms when they are proven. Emotional harm, reputational harm is not imaginary. People do actually suffer these types of harms. And if we're willing to award damages for these types of injuries in other contexts, in personal injury cases, in defamation cases, in privacy actions, we should be open to doing so here. That this vindicates the IP owner's interest to some degree, having full compensation. Defendants, generally speaking, should atone for their wrongful conduct, even if the damages are only symbolic. It is a way of society sending a message that the defendant has engaged in a wrongful act. And a more economically tinged argument, and this is really the argument that Professor Overhob makes in his paper on pain and suffering in patent cases, is that if we do not award full compensation, including damages for emotional harm, then infringers will not internalize all the externalities of their wrongful behavior. So again, if we want to have the optimal deterrence available, then we should award damages for all of the harm that is caused by the wrongful act. There also are some pretty strong arguments, though, for not going down this road. One argument, and this argument is often raised in relation to pain and suffering and personal injury cases as well, is that reputational harm, and especially emotional harm, is really not commensurable with money. It's just a different sort of thing. We value these interests in a different way. And so you will see commentators on both the right and the left, interestingly, arguing that maybe courts shouldn't award damages for these types of harms, that in a sense it commodifies human emotion. Also, damages for non-economic harm is really never going to be fully restorative. You may never really get your reputation back. You certainly aren't going to get back the emotional harm, the mental anguish that you have suffered. And perhaps more importantly than any of that is that the damages awarded for these types of harm, since they are not easy to quantify in any sort of objective sense, are likely to be arbitrary or inconsistent, unpredictable. Different people are going to be treated in different ways. There's not going to be equity either across the range of plaintiffs in a given case or among different types of plaintiffs for different ranges of injuries. So those are the general arguments for and against awarding damages for non-economic harm. Moving it on to IP cases in particular, here's basically where I come out on this. So I argue in the paper that, first of all, if a body of law, body of IP law in particular, is specifically intended to protect reputational or emotional interests, then I think there's a pretty strong argument for saying that injury to those interests should be compensated in some fashion. So that seems to be most obvious in the trademark sphere when we are talking about injuries to the trademark owner's goodwill or reputation, at least. Also for the right of publicity, to the extent it is grounded either in privacy or in the idea that people have a property interest in their name, image, or likeness. Injury to those interests should be compensated. even to the extent that that involves some sort of compensation for emotional harm or reputational harm. And certainly for moral rights, that seems to be a strong case as well, particularly if moral rights, the right of integrity in particular, is intended to protect the author's honor or reputation. It would seem natural that injuries to the honor or reputation of the author should be compensated in some fashion. You do get into some difficult questions when moral rights extend post-mortem, because often we don't think of a person's reputational interest as extending post-mortem. These are, again, personal interests to the author. Anyway, there's a brief discussion of that issue in the paper. Jenny McCutcheon, an Australian academic, has written a very good paper on that specific topic. Secondly, then, if a body of law is not specifically intended to protect these types of interests, then I argue that that alone is not dispositive, as long as protecting them would not undermine the body of law. Then maybe we should be open to the possibility that these interests would be protected. I argue, however, that allowing owners of patents and trademarks to recover damages for emotional harm actually would conflict with what I view as the more utilitarian justifications for those two bodies of law in particular, that inventors, trademark owners are more of a means to an end, a social end of promoting innovation and in the integrity of the marketplace. We shouldn't be as concerned about the individual owner's emotional harm, harsh as that may sound. However, if allowing recovery seems desirable in principle, at least in moral rights cases, trademark cases involving reputation, right of publicity cases, maybe copyright cases generally, there still is the question of how to quantify those harms, the measurement problem. And again, these are related inquiries, because if quantification problems are so great that we really can't overcome them, maybe that's an argument for not allowing recovery at all. So what are the options, though, if we think that some sort of damages recovery is desirable? The most obvious option is to allow the trier of fact, judge or jury, whoever it is, to award general damages, damages that are not necessarily tied to any quantifiable harm. Again, the problem is that allowing that can result in damages that can seem arbitrary and unpredictable. Maybe that would be an argument for having some sort of statutory guidelines. We know that in many countries there are guidelines for recovery of pain and suffering in personal injury cases that courts will look to try to achieve some sort of consistency. Maybe that could be done in this context, although I am somewhat skeptical of that. At the end of the day, I argue that in your run-of-the-mill IP case that does not involve willful or malicious misconduct, these sorts of general damages for non-economic harm, to the extent they are cognizable, should be limited to modest awards. And that's not a very precise rule, but largely speaking, it's what we have seen in most countries where damages have been awarded for violations of moral rights, for example. Often they are just nominal damages unless the defendant engaged in willful or malicious misconduct. Another possibility would be disgorgement of the infringer's profits in whole or in part as a remedy for these types of harms, although then you get into the problem, what if there is no profit to disgorge? Third possibility, and this is what the US court did in the graffiti case, was to award statutory damages. Of course, most countries don't have statutory damages for copyright or anything else, and maybe that's just as well, but that would be at least an option in the US. And then I talk about various factors that might be relevant when we think that something beyond a very modest or nominal award would be appropriate. Relevant factors drawn from case law in the United States, case law in Germany in particular, would consider the severity of the harm, the benefit to the defendant's culpability, and the need for deterrence. It's not going to lead to any precise outcome, but at least this is a way of sort of channeling the inquiry in the right direction. And so I will stop there. I don't know, Roy, you can tell me if we have any time for comments and questions, but that is my presentation.
Thank you very, very much for an excellent talk. I learned so much and benefited so much myself from your presentation. I think if you have any questions, I'll be very happy to unmute you if you raise your hand. Otherwise, you can type them in the Q&A box. I see one question, which is, I'm guessing the fact that moral rights in Europe are usually non-assignable as opposed to the US, it is easier to bring or at least invoke claims of prejudice.
Yeah, so again, even in the US, when we recognize moral rights, they actually are not assignable here either. They are viewed as personal rights that the author cannot assign. They can waive them, but they cannot assign them. It also is fair to say, though, as I think the questioner suggests, that the European countries generally take moral rights more seriously than US courts traditionally have done. And so there is certainly a much larger body of case law involving violations of moral rights and damages for moral rights violations. But again, even in Europe, typically when we were talking about monetary compensation, the damages most of the time tend to be fairly nominal unless the defendant engaged in a more willful or malicious campaign of violating the plaintiff's moral rights. And so there are a few cases, and I mentioned, I think, a couple of them in the paper, where fairly substantial damages have been awarded in Europe as well. The US case involving the graffiti artists is, I think, really the first case involving a really substantial amount of money for violation of the author's moral rights. There have been a couple of other cases I also mentioned in the paper that involve lesser sums awarded.
How do you see this in the bigger picture of awarding legal remedies? Courts have injunctions and damage awards at their disposal. What I see in Europe is that the matter is way more inclined towards injunctions, and damage awards are not playing a tremendously important role, which is also explained by the fact that there are no punitive damages. So even if we have our moral rights, in the end, the money you get for violation of your moral rights is not something where you can retire on by all means, right. Versus the US is generally more a damage award situation. How do you position this stuff that you talked about in this bigger picture?
Yeah, so that's an important consideration to take into account. Injunctions would be another way of trying to vindicate the author's or the IP owner's interest in these non-economic matters, in reputation, or in emotional stability, I suppose. And so an injunction will be a sufficient remedy in some cases, maybe, or at least good enough. It will at least provide some deterrent value as well if the infringer knows that they are likely to be enjoined and to suffer whatever harm they might suffer as a result of an injunction after they have incurred various costs to publish something or to create something. So injunctions certainly play into this. They're not going to be a sufficient substitute, though, for at least some of these types of things. To the extent moral rights protect authors against the outright destruction of their works, and I know there's a division of authority about whether moral rights actually should protect against something like destruction or not. But I think the modern trend has been in favor of that. Once the work has been destroyed or irremediably altered, an injunction is not really going to do you any good. You have to have some sort of damages, even if it is merely symbolic, as a way of showing that society takes this interest seriously. So injunctions are important. It is true that injunctions are, generally speaking, more available in IP cases in Europe than in the US, but they're available in most IP contexts in the US as well, most of the time. But damages also are an important component beyond that.
Then the other question that I would remark ahead is, I find it highly insatisfactory to say we are not going to do it because we can't do it. So we are not going to assess non-economic harm because we just don't have the economics to do it. This is the law of innovation. I think some of these arguments could probably be easier resolved by just working more interdisciplinary and benefiting more from the know-how of economists, rather than saying, you know what, let's just forget it, it's just too tricky to do.
Yeah, well, two things here. I mean, one, if it's going to be extremely difficult, if it's going to be so difficult to quantify the harm that the result will be that when we try to quantify it, we will have arbitrary awards, inconsistent awards. We will be treating similar situations differently. That is an argument for not doing it at all. I don't find it a compelling argument at the end of the day myself, but I mean, it is an argument for at least being somewhat cautious in allowing courts or juries to do whatever they think is just. There might be unintended consequences. But I would be in favor of having more input from economists on how we should value these types of interests. And there are a couple of interesting papers I have seen, experimental economics, trying to come up with some sort of framework for determining just how important are moral rights to authors, for example. How much do they value them? Also, some methodologies. In the most recent draft of the paper, I cite some work by Professor Hillel Bavli at SMU Law School in the United States on comparable cases. And he's talking more about personal injury cases, but I think his analysis could be more broadly applicable. Some way of trying to increase the consistency so that we don't have the inequity that might result from simply having each case be resolved on its own facts without consideration of preceding cases. So I do think at the end of the day, there are ways to make this a more rational process. I don't think we should give up. But the difficulty of doing this right, at least I think does suggest there also should be some caution in how we go about doing it.
Okay. You have inspired a lot of people. We have meanwhile gotten another 7 questions. If you had enough, you can say so.
No,
Otherwise,
I'm happy
I would
to go.
shoot all these questions at you.
I'm happy to go as long as you and the audience wants to go. So.
Mr. Leichtman is saying, what factors do you think should be considered for corrective advertising damages, if not based on defendants' advertising expenditures? Then Mayang Singh says, unfair competition could be a vehicle for claiming such prejudices and/or related damages.
All right. Yeah. So
then you just have a few compliments. Then you have a very, very long question, which I'll read separately.
All right. So let me take those first two in order. So what factors should be considered in awarding corrective advertising? I think the problem with the case law that we saw in the 1970s and 1980s in the United States from the Federal Trade Commission and from some of the courts awarding just 25% of the defendant's expenditures. I think that was problematic because often it was not tied to any consideration of the plaintiff's net worth. If I remember correctly, one of the cases, the amount awarded for corrective advertising was greatly in excess of the plaintiff trademark owner's net worth. So it was more than their goodwill even before the infringement occurred, which is a little bit hard to justify. So corrective advertising, when it is awarded, I think should be more closely tied to the amount that is reasonably necessary to dispel confusion, to try to revive the trademark's goodwill. And I think there are ways that economists today can at least try to estimate how to do that. Now, that gets to be expensive if you have to commission an economist to come up with some kind of econometric study. But to the extent we care about getting things right, up to a point at least, I think it does have to be tied to some extent to the plaintiff's net worth, which would be the extent of any possible harm to its goodwill, and it should not exceed that by some arbitrary amount. As for unfair competition law, so, I mean, yeah, unfair competition is one of those terms that I think everybody has their own definition of exactly what it means. In the US and in other common law countries, unfair competition was originally the genesis of trademark infringement, the right of publicity, trade secret law, false advertising law. It can encompass all of those various things, various ways in which one entity will compete in a way that we view as unfair, either for moral or ethical reasons, or because it undermines the integrity of the marketplace. It makes it more difficult for consumers to be able to rely on information to decide what things to buy. So unfair competition law is an important body of law. I guess I don't see it as a distinct body of law beyond what I've talked about here. I've talked about specific aspects of unfair competition law in relation to trademark infringement, trademark dilution, right of publicity. I guess I don't see it playing much of a role beyond that as sort of a standalone body of law, but maybe I'm wrong about that.
Okay.
And then there's a long question you said?
It's a very long question. I'm not sure. What moral rights should be treated, whether moral rights should be treated like personality rights or like IP rights? I'm asking because this interplay is very important when we deal with the choice of a competent court and decide jurisdictional strategy for online infringement. Precisely, we know that in the EU, the online damage and personality right infringement may be localized at the victim's center of interest. This means that, in the case, for example, of online defamation, the claimant may benefit from suing home for the damage suffered in all EU member states. By contrast, IP right holders are deprived of this opportunity. Normally, the court will not have international jurisdiction and will rule over domestic damages. The reason for this is strict territoriality of IP. Therefore, how do we deal with the moral rights of the IP owner? Are they also territorial as economic IP? May we bring an independent claim claiming moral rights of IP owners? Asks Maya Ochinaza from the University of Barcelona.
Okay, so yeah, so that's a really interesting question. And actually, it makes me think about, there's another paper I'm working on right now, hoping to finish this summer, on extraterritorial damages. And my focus in this particular paper is on patent law, but I am also looking at copyright, and I might write a subsequent paper on extraterritorial damages in copyright. And I am familiar with the EU case that you're talking about. There's a decision, I think it's called Cheval, from the early 1990s, where the Court of Justice held that for defamation in one single country, the court in that country may award damages for the harm suffered throughout the EU. It's not as clear whether that principle would apply in a copyright case, because copyrights and certainly patents and trademarks are viewed as being territorial in nature. So I guess all I can say is that I'm not entirely sure yet exactly how these issues should be reconciled or decided. And I don't think I have a deep enough knowledge of the European system and the very complex body of law dealing with online infringement and the right of communication and all of that to give a really authoritative, clear answer on this. But I think where I'm going to go in this paper I'm writing currently, which again is mostly focused on patents and only to a lesser extent on copyright, is that it makes sense for courts to award damages for all of the harm that is proximately caused by an act of domestic infringement, even if some of that harm extends beyond the borders of the country. So maybe at the end of the day, my conclusion will be that there really should not be any substantial difference between infringements of personal rights, such as defamation or moral rights, and these economic intellectual property rights that plaintiffs should be entitled to full compensation for all of them. I recognize, however, that then you run up against the countervailing principle that we generally do not want a court in one jurisdiction to weigh in on to adjudicate the validity of intellectual property rights granted in another country. So I'm not sure that I have a full-blown solution to that problem just yet.
We may soon have further insights from the UK on this matter.
What, say it again?
We may soon have further guidance from the English courts on these issues.
Oh, the Unwired Planet case, yes, yeah.
Eventually. Then there's another question. Do you have any views of inventors in relation to patents and patent applications? Example, malicious, asks Sidney Johnston. And then there's another question from Kuru Tiwari, who says, as protection of moral rights are optional for TRIPS members, what impact do you think it will have on the principle of reciprocity? It's two fairly different questions.
All right, the
so
first
one is on, okay, go ahead.
Yeah, so the first question, I'm not sure I completely understand the question, but let me take a stab at it.
The right of inventors in relation to malicious patent applications?
So Well, I guess that could be taken in either of two ways. So on the one hand, it might be the inventors who are the malicious entities, or it might be the infringers who are the malicious entities. The second situation is the one that Professor Avraham discusses in his paper advocating awards of non-economic damages in at least some patent infringement disputes. He uses as examples Philo Farnsworth, who was an inventor of one of the early prototypes of television, and Robert Kearns, who invented the intermittent windshield wiper. I think they've made movies about both of these individuals over the years. And the big companies, the big auto manufacturers, I think it was RCA in the Farnsworth case, went to great lengths to try to not recognize the patents, the IP rights of the individual inventors, and in both cases, the individual inventors really did suffer demonstrable harm, stress, mental anguish, depression as a result of the way they were treated. So Professor Avraham argues that in those cases involving willful or malicious misconduct by patent infringers, at least individual patent owners should be entitled to some sort of compensation, although he argues that in the US, maybe that can be indirectly dealt with through awarding enhanced damages, which is one of the earlier questioners points out is not really an option in most countries. Most countries do not award punitive damages. If it is the inventors who are the malicious entities filing patent applications as a way of trying to extract royalties from practicing entities to the extent there is abuse by so-called patent trolls or patent assertion entities, I think we have plenty of ways of addressing that, both in the United States and in Europe, and I don't know that we need any additional bodies of law to deal with it, but anyway, but I think I'll leave it at that on that particular issue. As for moral rights being optional under TRIPS, that is true, although most members of the WTO, to my knowledge, are also members of the Berne Convention, and so moral rights are mandatory for countries that are members of Berne, although then there's no effective enforcement mechanism if you don't recognize them. And then as far as reciprocity, so to the extent countries invoke the reciprocity principle under the Berne Convention, I guess they could deny moral rights to authors of nations that do not recognize the moral rights. But I think most members of the Berne Convention, which would then be most members of the WTO, do recognize moral rights to some degree. It is doubtful that the limited extent to which the United States recognizes moral rights really conforms to its obligations under the Berne Convention, but nothing is probably going to be done about that. It's a practical matter anytime in the foreseeable future.
Fine, we've gone massively over time. Under usual circumstances, we'd usually have a very nice speakers dinner. Guess we'll have a virtual speakers dinner. Thank you very much for this amazing talk. I have personally so much benefited from hearing you speak, and it has made so many new connections in my thinking. I'm really thankful that I had the chance to listen to your thoughts. I think our audience feels similar because they bravely lasted with us more or less, even though we went massively over time. And I think the amount of questions we got also shows people really liked your talk. Thank you really very, very much, and have still a lovely day. For us, it's basically nearly the end of the day.
Thank you very much. I was happy to participate and like to come back again at some point in the future. Thanks.
Oh, I'll hold you.
All right.
Sure. You will hear from me soon on this matter.
All right. All right. Thank you. Thank you. And
Bye.
have a good evening.
Bye.